Good afternoon. It's Thursday, February 15th. Conference room 325. This is the Committee on Consumer Protection and Commerce and Committee on Judiciary, Hawaiian Affairs. We have a number of bills on the agenda today. First bill, HB 238018, related to the Hawaii Nonprofit Corporations Act. And first up, I have Nalan. Steve Glanstein. Not present. Okay. All right, well, that's all of the testifiers I have on that particular measure. Next, House Bill 2317. Relating to planned community associations. Pamela Schnell.
Sure. Just.
Oh, you got it. Go for it.
Oh, okay. Thank you, Chair. Next, we have Steve Glanstein from the Hawaii State Association of Parliamentarians in Support on Zoom. Next, we have Bebe Bainum from Individual in Support on Zoom. Okay. Members, are there any more persons here to testify on this measure? Seeing none, members, we do have written testimony in support from Hawaii First Realty, Law Office of Mark and McKellar, Palihua Townhouse Association, AOAO Mariners Village 1, AOAO Waialae Place, AOAO The Continental Apartments, and we have written testimony with comments from the Community Association Institute, as well as several individuals in support. Members, any questions? Seeing none, we'll be moving on to the next measure, HB 2315, relating to condominiums. First to testify, we have Steve Glanstein once again. Is he here? Okay. Are there any other persons here to testify on this measure? Okay, seeing none, members, we have written testimony in opposition from the Honolulu Towers AOAO, as well as written testimony in support from AOAO Mariners Village, number 1, AOAO Waialae Place, AOAO The Continental Apartments, Palihua Townhouse Association, IP Expert of Honolulu, several individuals in support, and 12 individuals with written testimony with comments, and an individual in opposition. Members, are there any questions on this measure? Seeing none, we'll be moving on to the next, HB 2316, relating to condominiums. First to testify, we have Steve Glanstein, once again, support on Zoom. Are there any other persons here to testify on this measure? Seeing none, members, we have written testimony in support from Honolulu Tower AOAO, Palihua Townhouse Association, Law Office of Mark K. McKellar, AOAO Mariners Village number 1, AOAO Waialae Place, AOAO The Continental Apartments, AOAO Lakeview Standards, and numerous individuals in support, 2 individuals with written testimony with comments. Members, any questions on this measure? Seeing none, we'll be moving on to HB 2094. First to testify, we have, this is relating to the Residential Landlord Tenant Code. First to testify, we have Lindsay Garcia from Hawaii Realtors with comments.
Aloha, Chairs, Vice Chairs. My name is Lindsay Garcia from Hawaii Realtors. So we largely stand on our testimony offering comments, but just wanted to highlight that, we appreciate the intent of the measure, but we did want to point out that it's a bit vague about which specifically which locks would be affected by this measure. As I point out in my testimony, homes can have various keys for both front and back doors, as well as gates, storage areas, and so forth. And specifically when you think about condominiums, they may also have locks restricting access to entryways, common spaces, gyms, parking garages, etc. Some of these locks are commercial grade locks or key fobs, which can be very expensive to replace. And the measure can be broadly interpreted to require that locks would need to be replaced or changed for the entire condominium complex or home if, for instance, multiple unrelated tenants are living together, which would be burdensome, impractical, and affect other property owners or tenants living in the building or home every time someone moves out. So just wanted to seek clarity on this issue, but we do want to point out that it's already a good practice for property managers to change locks whenever a tenant moves out, so we don't necessarily believe that a mandate is required. Thank you.
Thank you. Are there any other persons here to testify on this measure? Seeing none, members, we do have written testimony in opposition from an individual, as well as one written testimony in support from an individual. Members, are there any questions? Seeing none, we'll be moving on to HB 2407 HD1. This is relating to wildfire risk mitigation. First to testify, we have Michael Angelo from the DCCA Division of Consumer Advocacy and Support.
Good afternoon, Chair, Vice Chairs, members of the committee. My name is Michael Angelo. I'm the Executive Director, Division of Consumer Advocacy. We support this measure and stand on our written testimony available for questions and appreciate the amendments from the previous committees. Thank you.
Thank you. Next, we have Blake Oshiro from the Office of the Governor in support.
Good afternoon, chairs, vice chairs, members of the committee. Blake Oshiro, Senior Advisor for the Governor. We'll stand on our written testimony in support. We wanted to thank you for scheduling this bill. This contains two different pieces of the pie that's necessary according to the utility in order to keep them and get them back into investment grade status. And so we are supportive of this measures as it has been amended, and I'm available for any questions. Thank you.
Thank you. Next, we have Chair Leo Asuncion from the Public Utilities Commission in support.
Good afternoon, chairs, vice chairs, members of the committees. My name is Grace Ralph. I'm the Chief of Policy and Research with the Public Utilities Commission. We support this measure and offered just a couple of comments. We appreciate the amendments made by the previous committees. And in this version, we'd like to offer just a couple of suggestions. The first is a small amendment to the definition of wildfire protection costs. The amendment that we're proposing would allow us as the Public Utilities Commission to determine whether the costs that would be securitized were prudently incurred. So this is another ratepayer protection measure. And then second, we want to offer a suggestion just to create consistency in the timeline for review of the different filings that would come in through this measure. Our amendment would also ensure that the parties to any proceeding get their filings in a timely manner so that we can also make our decision in a quick and timely manner. I'd be happy to answer any questions that you may have. Thank you.
Thank you. Next, we have Hawaii State Energy Office in support.
Chairs, vice chairs, members of the committee, Mark Glick, Chief Energy Officer, Hawaii State Energy Office. We stand in strong support of this measure, HB 2407. As previously stated, an important measure to do two primary things: add securitization or backup for ability for the utility and the projects moving forward to be adequately paid and financed, and of course important wildfire mitigation efforts to protect the state in the future and its inhabitants to avoid similar tragedies like what happened in Maui. Happy to answer any questions you may have. Thank you.
Thank you. Next, we have Randall Nishiyama from the Attorney General's Office with comments.
Good afternoon. Randall Nishiyama for the Department of the Attorney General. Given the specialized nature of securitization financing, we asked Craig Scully, the state's public finance counsel, to review the bill, and we've attached his markup of the bill. We'd be very happy to answer any questions that you may have. Thank you.
Thank you. Next, we have James Barros from the Hawaii Emergency Management Agency in support. On Zoom? Okay. Next, we have Jim Alberts from Hawaiian Electric in support.
Good afternoon, chairs, vice chairs, committee members. My name is Jim Alberts. I'm testifying on behalf of Hawaiian Electric today in support of this bill with several amendments. We have 4 sets of amendments. I'll give you a brief overview of each, and then I'll be ready for questions at the end. So the first amendment that we proposed is a clarification that the commission itself should determine the reasonable costs that it really takes to develop, deliver, implement, and administer the wildlife fund, or the wildfire mitigation plan, along with timely recovery mechanisms. The second, we struck the penalties clause because the PUC, the Public Utility Commission, already has the authority inside of HRS 26928 to impose penalties on the utility. The third is protecting the jurisdiction of the commission by adding limitations to sue regarding the wildfire mitigation plan once approved or modified. Now, this amendment only narrowly bars arguments that ask judges and juries to contradict the commission's express judgments. So it's a couple clarifications. No rights are lost. This is not a blanket immunity. And there's a specific recent case from PG&E in California where people sued the utility for their public safety power shutoff, so a preemptive shutoff program. And the California Supreme Court ruled in favor of the utility because that program was authorized and approved by the Public Utility Commission. So it maintained the authority of the Public Utility Commission to make those determinations rather than putting that into the courts. So the goal is not to create any new forms of liability. And the last amendment is for securitization. Now, what we proposed in this area is our technical amendments only. These are best practices for utility securitization designed to achieve the best possible ratings and ultimately the best price for customers. So we'll continue to work with the Attorney General's office and others to achieve acceptable language, but ultimately the commission will decide which costs can be recovered via securitization. So we ask that you please pass this bill with amendments, allow these discussions to continue. Thank you for allowing me to testify.
Thank you. Next, we have Beth Amaro from the Kauai Island Utility Cooperative in support on Zoom.
Yes, good afternoon, chairs, vice chairs, and members of the committee. We do support this bill with amendments that are proposed in our testimony, and I'll briefly summarize. It is unlikely that KIUC would seek a financing order as defined in the bill because we would be more likely to utilize our low-cost capital resources such as the Rural Utility Service. So this amendment would give KIUC a mechanism for cost recovery outside of the financing order, which is defined in the bill. And we're also proposing an alternative definition of wildfire that would be pegged to the cost of the incident versus the number of structures. And I'll be happy to answer any questions. Thank you.
Thank you. Are there any other persons here to testify on this measure? Seeing none, members, we do have written testimony with comments from Department of Budget and Finance, supportive testimony from U'upono Initiative, IBEW Local 1260, individual with comments, and individual in support. Members, any questions? Representative Lowen.
I guess for consumer advocate. So I know when we last heard this bill, I think we asked the question if you thought there should be additional provisions in the bill kind of detailing what should be addressed in any kind of financing order and how this should be addressed moving forward to make sure we have the maximum protections for ratepayers. But I don't see any additional suggestions in testimony suggesting any changes to the bill. So has there been any further thought given to that or work done on it?
We've been contemplating it. It's something that we have some outside experts looking at, and we're going to be discussing tomorrow. So I can get back to you on that.
Okay, that would be good.
Okay.
And I guess regarding, HECO has requested amendments. This might actually, I'll ask the PUC. So.
Okay.
Never mind. If I can continue with the chairs, okay?
Yes.
Public Utilities Commission. Just wanted to know your opinion on, like, HECO's suggested amendments, I think, are asking for essentially a liability exemption. Once the plan is approved, the wildfire mitigation plan is approved, then all the liability would shift to the PUC or the state presumably. So how do you guys feel about that?
Yeah, I think we would want to ensure that there are processes in place to review the actions of the utilities. So I don't think we would agree with a blanket removal of, or a blanket protection, I guess, in that sense.
All right, thank you. And then for Hawaiian Electric? Hi, Jim. I think I had some questions. I mean, last time you were here, we had multiple questions, including, whether HEI had looked internally at their own company and ways to ensure that they were asking the least amount from ratepayers and taxpayers as possible. And you had said you were just here to talk about the mitigation plan and not that, and there's no one here from HEI. Is there anyone here from HEI to answer those questions today?
No, and I mean, I would just comment here that the costs from HEI aren't paid for by customers, so they're paid for by shareholders. So those costs don't get included in these rate decisions. And the way the rate process works, which I know you're familiar with, is we file these applications with the Public Utility Commission, and then through a rigorous vetting process with interveners, the commission, the consumer advocate, those just and reasonable costs are decided, and then the Public Utility Commission provides a decision.
Yeah, but I mean, the authorization of this securitization process is providing you, the company, with access to capital you wouldn't have otherwise, and I think that all of the payback for that gets put on to ratepayers. And the need to ask for what amount you might ask for could be offset, depending on how the company looks internally at its own operations.
Yeah, I can assure you, like I did last time, the companies are looking at every opportunity to cut costs and save money. And when we look at the securitization bill in particular, that still has to come before the Public Utility Commission, and they make the ultimate decision on what costs actually are included in the securitization.
I understand. And then the last time, when we had these questions in the last committee as well, we were trying to get a handle on some kind of numbers we might be talking about just hypothetically, and I think at that time you were unable to provide us anything, but we did talk to the Energy Office, and they talked to HDIA and just sort of ran some, what if it was a bond for $500 million, what if it was bond for $1 billion or $2 billion, and came up with some numbers. So
well, I can't give you a number because we do have to go through the process to determine what that cost is. So we did some research too, and I have just a rough number. So hypothetically, if we did go out and ask for $1 billion worth of securitization, 30 years at 5.47% would lead to a $5.27 increase in a monthly bill for customers on Oahu. So assuming a $195.90 average bill, that's about a 2.6% increase. Now
for $1 billion bond.
For $1 billion bond.
Because the numbers that we heard, and maybe I'll have Energy Office speak to that as well, and that was sort of based on, what it would look like with a 5% loan and a 6% loan. We're like double that for $1 billion. That was closer to the amount that it looked like for $500 million. So there's some discrepancy there in how it's being calculated.
Well, I don't know. These are provided from experts that do this for a living in the bond markets.
Okay.
So the one thing I did want to mention too, though, to your question about the costs and why should customers pay for these things, this is similar to any project that the utility would do and ask for a general hearing or a rate case eventually to recover those costs. So these, like for the wildfire protection plan, those are assets that would be installed in the system to protect the customers. So when we go through the process and the PUC makes a determination on that, they'll decide that just and reasonable cost.
Yep.
So they're specific for customers.
Yep. Okay. All right, thanks.
Thank you.
Members, any further questions? Okay, seeing none, we'll be taking a short recess for decision-making. Recess.
Okay, reconvening our joint CPC JHA meeting on a number of bills for decision-making. First up, House Bill 2318 related to the Hawaii Nonprofit Corporation Act. On this particular measure, Chair's recommendation is that we just effectuate this and move it forward. Members, any questions or comments? CPC members, any questions or comments? Seeing none, Vice Chair.
Voting on HB 2318, Chair's recommendation is to pass with amendments. Chair, Vice Chair vote aye. Representative Amato? Aye. Representative Belatti?
Aye.
Representative Hashem? Representative Hussey Burdick? Excused. Representative Gates? Excused. Representative Lowen?
Aye.
Representative Onishi?
Aye.
Representative Tam?
Aye.
Representative Purick? Aye. Thank you, Chair. Your recommendation is adopted.
For the
Thank you very
Judiciary
much.
and Hawaiian Affairs Committee, if I may, Chair?
Yeah.
Go.
For Judiciary and Hawaiian Affairs Committee, recommendation is the same, pass HB 2318 with amendments. Questions or concerns, members of Judiciary and Hawaiian Affairs? If not, Representative Miyake for the vote.
Thank you, Chair. For House Bill 2318, Chair votes aye.
With amendments.
I'm sorry, with amendments. Chair votes aye. Vice Chair Takayama excuse. Chair, Representative Evslin. Aye. Representative Ganadin. Aye. Representative Hope. Aye. Representative Ichiyama. Aye. Representative Iligan. Aye. Representative Kong. Aye. Myself vote aye. Representative Souza. Aye. Chair, your recommendation is adopted.
Thank you. Back to you, Chair Nakashima.
Thank you very much. On House Bill 2317 related to planned community associations, Chair's recommendation again is to defectate this, and I guess I should state a date, July
3,000.
July 1st, 3000. Members, any questions or comments? Seeing none, Vice Chair.
Voting on HB 2317, Chair's recommendation is to pass with amendments, noting the excused absences of Representative Hussey Burdick and Gates. Any members voting with reservations? Any members voting no? Thank you, Chair. Your recommendation is adopted.
Thank you very much.
For Judiciary and Hawaiian Affairs Committee on House Bill 2317, recommendation is to pass with amendments. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on House Bill 2317, same recommendation. Noting the excused absence of Vice Chair Takayama, any reservations or no? Seeing none, Chair, your recommendation is adopted.
Thank you.
Thank you very much. Next, House Bill 2315 related to condominiums. Chair's recommendation is, again, for technical amendments needed for clarity, consistency, and style, and a defect date of July 1st, 3000. Members, questions or comments? Seeing none, Vice Chair.
Voting on HB 2315, Chair's recommendation is to pass with amendments, noting the excused absences of Representatives Hussey Burdick and Gates. Any members voting with reservations? Any members voting no? Thank you, Chair. Your recommendation is adopted.
Thank you. For Judiciary and Hawaiian Affairs, recommendation on House Bill 2315 is to pass with amendments. Any concerns or questions? If not, Representative Miyake for the vote.
Voting on House Bill 2315 with amendments, noting the excused absence of Vice Chair Takayama, are there any reservations or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much.
Thank you. Next, House Bill 2316 related to condominiums. Chair's recommendation is to include technical amendments needed for clarity, consistency, and style, and to defect date this July 1st, 3000. Members, questions or comments? Seeing none, Vice Chair.
Voting on HB 2316, Chair's recommendation is to pass with amendments, knowing the excused absences of Representatives Hussey Burdick and Gates. Any members voting with reservations? Any members voting no? Thank you, Chair. Your recommendation is adopted.
Thank you. For the Judiciary and Hawaiian Affairs Committee on House Bill 2316, recommendation is to pass with amendments. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on House Bill 2316 with amendments, noting the excused absence of Vice Chair Takayama, are there any noes or reservations? Seeing none, Chair, your recommendation is adopted.
Thank you.
Thank you very much. Next, House Bill 2407 related to wildfire.
Oh,
Oh, I'm sorry. 2009. I'm sorry. House Bill 2094 related to the residential landlord tenant code. Recommendation is technical amendments needed for clarity, consistency, style, and the effect date July 30, to July 1st, 2000. Members, questions or comments?
Chair?
Yes. Representative Onishi.
Yeah, thank you. I have concerns in regards to condominiums and its impact on, for example, the farbs that get you in and out of the building, the security, and whether or not, they are programmable or do they need to be replaced? If you have 100 units, that means all 100 tenants would have to get that replaced. I don't know what the cost would be to the association or to the individual tenants. I think we need to consider, maybe some way to make this mandatory on maybe just single-family dwellings instead of multiple unit buildings where costs might exponentially rise because of the many tenants in the building. So with that, I'll be voting with reservations.
Thank you very much, Representative Onishi. The chair is cognizant of the concern, and the intent is to include in the committee report language to the fact that keys accessing general areas or common areas would not be included in this, and it'd be more limited to the individual living spaces of tenants. Members, any other questions or comments?
Chair,
Yes, Representative Tam.
thank you. I'll also be voting with reservations. I do share the same concerns. This also includes like walk-ups with access keys and storage space as well. So I think that we need to be cognizant of that, especially if we're going to see who fronts the cost. Can the landlord send the cost over to the previous tenant or the future tenant about changing the locks as well? So for that, I'll just be voting with reservations.
Okay, thank you very much. Members, any other questions or comments? Seeing none, Vice Chair, as amended.
voting on HB 2094, Chair's recommendation is to pass with amendments, knowing the excused absences of Representatives Hussey, Burdick, and Gates. Any members noting the reservations vote for Representative Onishi and Tam. Any members voting with reservations? Any members voting no? Thank you, Chair. Your recommendation is adopted.
For Judiciary and Hawaiian Affairs on House Bill 2094, same recommendation, passed with amendments. Questions or concerns? Representative Kong.
Sorry, I didn't hear clearly, but he's going to put it in a committee report?
Chair's intention is to put in the committee report.
Okay, thank you.
Any other questions or concerns from Judiciary and Hawaiian Affairs? If not, please take the vote. Representative Miyake?
Voting on House Bill 2094 with amendments, noting the excused absence of Vice Chair Takayama, are there any noes or reservations? Seeing none, Chair, your recommendation is adopted.
Thank you very much. Go ahead, back to 2407.
Okay. Okay, thank you very much. Next, House Bill
Recording stopped.
2407, relating to wildfire risk mitigation.
Wait,
Chair-
wait. Brief recess. We've had the recording stop. You want to do a recess? You want to recess?
Brief recess.
Okay, reconvening the joint CPC JHA hearing, February 15, 2024, picking up on House Bill 2407 related to wildfire risk mitigation. Chair's recommendation is that we adopt the proposal from the Attorney General's office. Members, any questions or comments?
Chair?
Representative Onishi.
Yes, can I get a ruling on potential conflict of interest?
Sure.
Yeah, I own Hawaiian Electric stocks.
Okay, I think that is part of a much larger class of people, and so I think you are okay to vote. Members, any other questions or comments? Seeing none, Vice Chair, AG proposals.
Voting on HB 2407 HD1, Chair's recommendation is to pass with amendments, noting the excused absences of Representatives Hussey, Burdick, and Gates. Any members voting with reservation? Any members voting no? Thank you, Chair. Your recommendation is adopted.
For House Bill 2407 HD1 for the Judiciary and Hawaiian Affairs Committee, recommendation is to pass with amendments, specifically taking the Attorney General's amendments. So we'll be passing out HB 2407 HD1 with amendments. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on HB 2407 HD1 with amendments. Chair votes aye, noting the excused absence of Vice Chair Takayama. Any reservations or noes? Seeing none, Chair, your recommendation is adopted.
Thank you very much. You want to move to your decision-making on the last bill?
Oh, you want me to? Okay, members, we'll be taking up a measure, HB 2606 HD1 relating to transit accommodations. This is related to our Consumer Protection and Commerce Committee, the measure we took on February 8th, 2024. This is the decision-making for that. While I do appreciate the intent of this measure, I think this still needs to be worked through with the industry experts and necessary stakeholders over the interim, so I'll be deferring this measure. Thank you. We'll be adjourning this hearing.
Let's go ahead and start the next hearing, which is joint committee hearing of Judiciary and Hawaiian Affairs and the Committee on Consumer Protection and Commerce. It is Thursday, February 15th, 2024. It's 2:44 p.m. here in conference room 325. So this is the 202 agenda. First up, we have House Bill 1916 relating to the disclosure of personal information associated with certain public servants. First up, we have testimony from the judiciary. Welcome. Please introduce yourself and proceed.
Yes, good afternoon, chairs, vice chairs, members of the committee. I'm Thomas Berger. I'm a staff attorney. So the judiciary stands in strong support of this bill, which is part of the judiciary's package legislation. The pressing need for this bill is detailed in the preamble to the bill. I mean, we all recall the horrific attack on Speaker Nancy Pelosi's husband at their home. And in the preamble of the bill, there's just example after example of horrific acts of violence that are happening at our public servants' homes. And I hate to kind of go over them because it's sad and it's tragic to have this happening at the homes of our public servants. So this bill proposes a solution, which is to allow, it's modeled on a similar federal law which has been passed by Congress, and it would allow the public servants to request to have certain personal information removed from the public record. For example, your home address. And, the bill is carefully crafted to protect First Amendment concerns. If a member of the public still wants to get the record, they can request the record, but the information is going to be redacted. And if the news wants to report on something that's newsworthy about a particular thing that involves somebody's home and it's newsworthy, they can report on it. So it's a carefully crafted and narrow bill that should hopefully prevent continued acts of violence at the homes of public servants. So I'm available to answer any questions as well.
Thank you very much.
Thank you.
Next, we have testimony with comments from the Office of Information Practices. Director Park, please proceed.
Aloha. Cheryl Kakazu Park, Director for the Office of Information Practices, or OIP. We support the intent of this bill, and we see the great need to protect our judges and public servants, but we see a lot of potential problems that this bill poses with respect to the Uniform Information Practices Act, or UIPA, which is Hawaii's Open Records Act. For one thing, the UIPA mandates that certain information be disclosed publicly, and that would include property ownership information and property tax records. So this bill will always be in conflict with the current requirement in the UIPA that home addresses, for example, are going to be disclosed as part of the property records. And there are other provisions in the mandatory disclosure provisions of the UIPA that will probably also come into conflict with provisions of this bill. For example, like minutes of public meetings are required to be public, but if in the minutes you have some kind of passing reference to the name of a school, of a protected person's child, or a spouse, or an employer of the spouse, of that person's spouse, it would conflict with this bill to keep such information confidential. Now, it would be very impracticable and unworkable for government agencies to completely go through anything on their websites or in their records that may implicate the private information that this bill proposes to protect, because the person can make a request to keep specific information out of records, but they don't have to specify which particular records within an agency's vast documents would have to be looked at. I'll be available to answer any further questions.
Thank you very much. Next, we have testimony from the Department of Land and Natural Resources. Mr. Kobata, welcome. Please proceed.
Thank you, Chair. Aloha chairs, vice chairs, members of the committee. I'm surprised my testimony made it. I've passed out a second set of testimony.
Thank you. Everybody did receive your testimony,
Thank you.
albeit late, but it was distributed to all the members.
Thank you very much. I'm representing Department of Land and Natural Resources. My name is Les Kobata. I'm the registrar for the Bureau of Conveyance. And we stand on our comments and actually more of our concerns, and would hope that the committee has a chance to review them. I think you'll hear throughout the testimonies of various people coming up today that there are some concerns, not with the intent, clearly. I mean, there's a need to protect our public servants, to protect our judges, and a number of other people. It's the implementation of that protection. Very simply, in my office alone, we have paper records, and if we were having to redact information from paper records, not a very practical thing for us to be able to do. Anything electronic, I don't know that many departments or divisions are equipped or staffed, let alone funded, to be able to redact information from our records. So we offered some recommendation as well. There are some states who are doing different programs that are much more coordinated on a statewide basis, taking into account the different stakeholders' concerns and trying to come up with something that's a little bit more workable. So I'll be here to answer any questions you have. Thank you.
Thank you very much. Next, we have written testimony in support from the City and County of Honolulu, U.S. District Court of New Jersey. We have testimony in opposition from the Public First Law Center.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Ben Krebs. I'm testifying on behalf of the Public First Law Center. We broadly support the intent of this measure, but we do oppose it as written. Our main concern is the public records exemption that it creates and the potential for abuse or misuse in applying that UIPA exception too broadly. And we would point out that there are existing protections under UIPA, mainly the privacy exemption that keeps a lot of the information that is the subject of this bill from being disclosed to the public. Now, that is separate from the mandatory real estate, real property disclosures, and I think, as OIP noted, that is a, inherent conflict with this bill. In our testimony, we linked to federal congressional testimony that highlights the role of data brokers in this issue, and these are the companies that are scraping and selling information that they gather from mobile devices and from credit applications, not necessarily public records. And we've offered a few other comments in our written testimony, and I'm available for questions. Thank you.
Thank you very much. And we've received written testimony and support from the Hawaii Government Employee Association, the Hawaii State Bar Association, and the American Judicature Society Ad Hoc Committee on Judicial Security. Is there anyone else here wishing to testify on HB 1916? Yes, please come on up, introduce yourself.
Aloha, chairs, vice chairs, members of the committee. I am Dr. Adam Jansen, and I have the privilege of serving as state archivist and administrator of the public archives. I do apologize for not getting testimony in. We just read this bill last night. I absolutely do support the intent, but need to bring up the concerns of the implementation issues. As the public archives, we receive record from hundreds of record creators. We don't know the content of these things. Social media alone, we have protected over 500,000 photographs from hundreds of social media accounts. We cannot implement this bill. We don't know if somebody was hanging out with their friend who happens to be a retired judge and took a picture of his nice new Corvette. We cannot implement this. And we don't want to be in fault of this law. There are already UIPA requirements, Uniform Information Practices Acts, to not use any acronyms, that require us to redact records when the public asks for copies of those. But that's just the small portion of the things you're asking us to protect. Along with family, relatives, live-ins, we don't know who these people are, and when it extends to retirees as well, we could have records going back 50 years from these individuals where they filled out an application for elections, and it happens to have their address on it. So we ask for some consideration of that and understanding of when you have these huge collections of public record that are not created by your agency, we simply cannot implement this. So I appreciate the opportunity to share my concerns, and I welcome any questions or comments you may have.
Thank you, Dr. Jensen. Other testimony? Mr. Louis Kwan, please introduce yourself and proceed.
Aloha, Chair Tarnas and Chair Nakashima, Vice Chair Sayama, and members of the committees. My name is Ivan Louis Kwan. I'm with the American Judicature Society Ad Hoc Committee on Judicial Security. And we are in very strong support of HB 1916, and we stand on our written testimony. Thank you.
Thank you very much. Anyone else wishing to testify on House Bill 1916?
I will just say, my name is Michael Seabright. I'm a United States District Court judge. Thank you for inviting me to your house. Normally I'm on that side, not this side, looking in. Obviously, the federal court and the judges support the bill. I understand what people have said here today about some of the implementation issues. Certainly, we're more than happy to work with anyone to try to solve those. But there are real threats out there. There are real threats that are consistent and ongoing against judges across the country. And so I can only speak on behalf of the judges, but I ask that you all give serious consideration to the bill. Thank you.
Thank you very much, Judge Seabright. Anyone else wishing to testify on this measure? If not, questions, members? First to Judiciary and Hawaiian Affairs, questions? If not, do you want to ask
Members, Commerce Consumer Protection, Representative Bellotti.
Mr. Louis Kwan. You know, looking at this, and myself having been an elected official who had to actually get a TRO against someone, I think there are a number of us who've had to do that with concerns. But I think there is a special concern, particularly for judges who are a different kind of class of public servants, because you folks deal with very specific conflicts. In the conversations that happen at the federal level, is there a different tact being taken for other federal employees versus, and that's why they settled on the law applying only to judges initially? Can you speak to some of that?
So I think Judge Seabright is probably in a better position as a federal judge to understand the implementation of the federal law. But as I understand it, one of the reasons that in the federal law it was restricted to the judges was because of the breadth of the scope of the protection. and the required implementation and compliance. For example, it's not just setting up a law, but also having a mechanism which the federal judiciary puts in place to ongoing monitor data that data brokers sell to online companies, and making sure that when the data is put online, that that somebody's monitoring and what they call the notice and removal provision. So it's an ongoing process, and that's one of the reasons that the scope of this bill is relatively limited. It's limited to judiciary members, judges, to administrators on the executive branch and legislators. And so otherwise, everybody wants protection, but it's really the question of the reality in implementation and actual compliance.
Thank you.
You're welcome.
Thank you.
Other questions from the Consumer Protection?
Representative Parrott?
This question is for Judge Seabright. Thank you, sir, for coming to testify.
Thank you for having me.
So I understand the concern for wanting to protect judges, and there's also a high desire of the public to have access to their servants. So like the governor of New Hampshire, Sununum, his personal cell phone number is out there for people. In early America, people would walk up to the president's house and just walk in and talk to them. What are your thoughts on giving people access to their servants that closely while trying to balance the intent of this bill?
Well, I think, first of all, I do want to reflect my comments are limited by my ethical constraints as a federal judge, and so I will limit my comments somewhat. But I certainly understand the public's right to have access to the courts, and I certainly respect the media and the intent of making sure that as much information as public as possible. We are, in many respects, the most transparent branch of government, in my view, because I don't make a decision without putting it in writing and saying why, or from the bench saying why I'm making a certain decision. I don't make decisions and it gets hidden, behind something as to why I'm making a decision. It's out there, it's public, it's for everyone to view. But in the judiciary, it's never been part of the system where the public can come up and talk to the judge and try to convince the judge to rule a particular way or have access to the judge. The courthouses are public and open. We have a lot of security in the courthouses. I feel very secure in our courthouse. I can't speak for state judges, but I think that the U.S. Marshal Service does an excellent job in protecting us within our home, the courthouse. Where it gets challenging is as soon as we leave the courthouse. And that's where there have been over the years many federal judges that have been killed, or family members, such as Judge Solis, who presented some testimony, whose son was tragically killed because he was the one that opened that door that day. When that disgruntled litigant, he was a lawyer actually, showed up in a FedEx uniform, so the door would be opened, and then opened fire and killed her son and then shot her husband 5 times. She was the target, but it ended up her son was killed and her husband had to go through multiple surgeries. And that's the most recent example. There's a judge in Maryland who was killed on a federal level in his driveway recently. After court that day, someone was upset, as I understand it, with what happened. And they found his home address, drove to his house, and killed him in his driveway. And there have been other federal judges that have been assassinated over the years and killed. And what we just see on a daily basis, on a consistent basis, is the increase in the threat level that we get. Sometimes we get it directly. Sometimes it comes through third parties. We're fortunate we have the U.S. Marshals who can provide protection for us. But of course, that's not foolproof. And they don't live with us in our homes. So that's as best as I can answer your question. I hope it somewhat satisfied your question. Okay. Thank you.
Any other members from CPC wishing for questions?
If not, back to Judiciary and Hawaiian Affairs for questions. Representative Gannon?
To the judiciary. First off, thanks to the Honorable Michael Seabright for his appearance today. It's really a rare opportunity to hear directly from the federal bench. Can you explain the kind of ethical duties that the judge was just explaining? For example, the appearance of impropriety that judges are bound to, as well as the kinds of things that they are held to ethically that differentiate them from other public servants? And why specifically this is needed for them, like that, specifically the impropriety thing?
So if I understand your question correctly, you're trying to ask if there's a special need for judges for protection tied to their ethical requirements, maybe?
I'm trying to get you to articulate, hi, Judge Viola. I'm trying to get you to articulate the differences in ethical duties that judges have from other lawyers and other public servants. I know them to be quite significant.
Yeah, I mean, there's a lot of, I mean, there's restrictions on judges, like ex parte communication. So, but to kind of bring it back to the bill, I mean, this bill doesn't really have to do with ethics. But I think, you know, society has really advanced. The technological advancements that we have now and the ability to access information, it wasn't there even when I was a kid, right? So I think with the times changing, policy kind of has to catch up, right? So, you know, this bill is narrowly crafted where the public can still get the record, but the specific information that we know is being used to target policymakers will be redacted. So, yeah, thank you.
All right, thank you.
Other questions, members? Representative Gannon, do you have further questions?
I see Judge Viola looking at me for his potential response to this.
If you would like to ask him.
Yeah, Judge Viola, maybe I redirect my questioning to you, here at the First Circuit.
I saw you looking at me too, so I'm Matt Val, I'm the Senior Family Court Judge in the First Circuit. I think to Representative your question, I think in some respects we are different from other public servants in terms of how our role. We decide cases and controversies. We have strict limitations on the information that we base our decisions on. There are ethical prohibitions about what we call ex parte communications from members of the public. There are prohibitions in our Code of Judicial Conduct which prohibit us from making decisions based on public opinion. So I think to your point, we're out there. We're happy to be transparent and accountable to the public, but the way we interact with the public, I think, is different in kind from some other public servants, including yourselves. Was that what you were asking for?
Thank you, Your Honor. Yes.
Okay.
Thank you. I have a question for the judiciary, if other members don't have questions. This measure is, you described it as being narrow, but in fact it's much broader than a measure that we considered last session, House Bill 386, which we moved out of the Judiciary and Hawaiian Affairs Committee, which was also a judiciary package bill that prohibited, in certain circumstances, the publication of the personal information of federal and state judges and other judicial staff whose duties put them at risk for acts of violence or threat. So it was very narrow, just focusing on judges and judicial staff. This measure is significantly broader because it includes a whole lot of other folks, public, elected officials, agency directors. In the testimony on HB 386 HD1, we didn't get all this opposing testimony. We didn't have any of these concerns that we have on this bill. Your interest really is in the judges and the judicial staff, really. I mean, you included everyone else in this bill, but your interest is really focusing on the judges and judicial staff.
Yes, Chair. I mean, the feedback that we got last session was, why is it only applying to judges?
Now, you didn't get that feedback from
not
the House?
Here, not here from the House, no. But perhaps
somebody else?
Yeah, from somewhere else, right? And maybe your friends at the Senate. But that was the feedback that we got. So I think the challenge with the bill last year, too, was also the title. I think the title was it was a narrower description, right?
It was relating to the safety of judiciary personnel.
Yeah, but yeah, to answer the chair's question, that is correct. Our primary concern is the safety of the judges, but from a policy standpoint, we included the other, the governor, lieutenant governor, and it is much broader. So we would defer to the committee in terms of what's appropriate.
Okay. Thank you. Because it just seems like it might be much simpler if we just moved forward with what your original plan was back in 386.
Yes, sir.
And didn't seem to have all this opposition, so.
Yes.
Okay, thank you very much.
Thank you.
Any other questions from Judiciary and Hawaiian Affairs? CPC? If not, let's move on to the next bill. Thank you very much to the testifiers. Next bill, House Bill 2524, relating to condominiums. First up, we have testimony from the Office of the Ombudsman. Mr. Matsunaga, pleasure to see you, sir.
Aloha chairs, vice chairs, members, Robin Matsunaga, State Ombudsman. Thank you for allowing me to submit comments on, specifically on Section 1 of the bill, and I'm available for any questions you might have.
And just so for those who didn't have a chance to read it, you said it's hard to estimate how long it's going to take for you to finish your investigations.
Any investigation.
Any
that we
investigation.
conduct. Investigations that we think might take 2 or 3 days, sometimes take 2 months. And investigations that we think might take 6 months, sometimes we're done in 2 weeks. It really depends on the availability of witnesses that we identify that have information that we need to evaluate what the agency did, and also the ability to obtain documents and other types of evidence that we need to evaluate the complaint.
Thank you for those, that explanation. Appreciate it, Mr. Matsunaga. Next up, we have testimony in opposition from the Hawaii Real Estate Commission.
Good afternoon, chairs, vice chairs, committee members, Keaton Kleinhans, condo specialist, testifying on behalf of the Real Estate Commission. We sent out a written testimony in opposition. We'll highlight that certain provisions require the commission to delegate its ability to receive and investigate complaints to DCCA RICO. They do have a complaints process in place. Those provisions are listed in our written testimony in 514B. We do seek clarification on the intent of Section 2, but if it's possibly to expand the Commission and RICO's authority, we do respectfully suggest consideration be given to the CPM task force established last year by Act 189. And those bills introduced this session for LRB study on condominium governance. Thank you. Available for any questions.
Thank you very much. We have testimony with comments from the Community Associations Institute.
Thank you, chairs, vice chairs, committee members. My name is Phil Nerney. I chair the Legislative Action Committee for CAI. As it happens, I am also the chair of the task force that the legislature appointed last year to investigate condominium law. The unanimous recommendation of that task force was to have the Legislative Reference Bureau conduct a study with respect to a variety of matters, including condominium ombudsmans. That is reflected in House Bill 1814, which is moving and which we hope will pass. So to the extent that this bill would effectuate a condominium ombudsman, we think that that should be the subject of study. Thank you.
Thank you very much. Members, we have testimony with comments from Hawaii First Realty, testimony in opposition from Honolulu Tower, AOAO, numerous other organizations, testimony in support from other organizations as well. In total, we have 15 in support, 20 in opposition, and 4 with comments. On Zoom, I think we may have some individuals. Dale Head, please proceed. Dale Head. You could unmute yourself and turn on your video. Dale Head. Okay, next we have on Zoom Greg Misakian. Please proceed.
Aloha, chairs, vice chairs, and members of the committees. My name is Greg Misakian, and I currently serve as second vice president of the Kukua Council, Subdistrict 2 vice chair of the Waikiki Neighborhood Board, and a director on my condominium association's board. While I support the intent of this bill, I have serious concerns regarding the Real Estate Commission overseeing any investigation into condominium owners' concerns, as the Real Estate Commission is stacked with those who openly side with boards and management companies. One clear example of this is a real estate commissioner who is a VP of Government Affairs for Associa Hawaii, a management company that was operating unlicensed from January 1st, 2023 until April 10th, 2023. This is a clear conflict of interest. The owners at my condominium association voted out Associa Hawaii in March of 2022, yet they are still overseeing my association. I ask the committee members to please do what's best for over 1/3 of the population and amend this bill to place an ombudsman's office for condominium associations within the DCCA, either under the Office of Consumer Protection or as an independent office. There are well-written ombudsman bills introduced and available with details, so much of the work is done for you. I also ask the committee members to please be aware that most of the opposition's written testimony is the same boilerplate cut and paste testimony. I counted 14 for this hearing. There is one group who is profiting more from less consumer protections for the public. If this is what the committees are relying on for decision-making, it is of serious concern. I also noticed a resident manager, a parliamentarian, and others who submitted testimony on behalf of their associations. The question our legislators should be asking is, do they have the authority to do this and a valid and documented majority vote by the owners? And to conclude, you have the right word in this bill, ombudsman, but not the right process. I ask you to please help over 1/3 of the population of Hawaii today and support this bill with the amendment I have suggested. I am available for any questions, and I appreciate the time. Thank you.
Thank you, Mr. Masakian. Did Dale Head make himself available on Zoom? If so, please proceed. Mr. Head?
Okay, I hope you can hear me now.
Yes, please proceed.
Sorry, it's hard for me to find the button on a tablet. Hey, this goes back to the Equal Protection Clause of the U.S. Constitution. And people live in HOAs and multiple family dwellings are not receiving equal treatment. Let me clarify. Well, perhaps as much as 40% of Hawaii population now reside in HOA-type dwellings. It's really like warehousing people. Such residents are told they necessarily must give up some rights by living on that property, supposedly as it is self-governed. Indeed, when there is misconduct by power-hungry boards of directors, members, or managing agent property managers, there is no ombudsman available to turn to. Basically, it is impractical for victims of bullying, which are made under color of authority, to undertake the arduous challenge of speaking and writing to hundreds of other owners seeking to remove that person from authority. This current imbalance of power can be addressed by availability of an ombudsman office to provide timely action, and that may be empowered to remove a board member or managing agent. Thank you.
Thank you very much. Next, we have testimony from Bebe Bainum. Not present. That's all the testimony from people who said they would testify in person or on Zoom. Is there anyone else here that would wish to testify on HB 2524? Seeing none. Members, questions? First from Judiciary and Hawaiian Affairs? If not.
Members of Consumer Protection and Commerce, questions? Seeing none.
Okay, thank you very much. Members, those first two bills are the ones that we have jointly referred to Judiciary and Hawaiian Affairs and Consumer Protection and Commerce. So let's move directly into decision-making on those two measures, and then members of CPC would be excused so that we can continue on to the rest of our agenda. So moving up to the top of the agenda, HB 1916, relating to the disclosure of personal information associated with certain public servants. Following up on my comments about a previous bill that we moved out of the Judiciary and Hawaiian Affairs Committee, House Bill 386, HD1, passed the House, went over to the Senate, had hearings in Judiciary in the Senate and Ways and Means in the Senate, and did not move out of Ways and Means. It was focused specifically on judges and judicial staff, and did not receive the negative testimony and opposition that we have received on this measure. I recommend that we insert language, we pass out a House Draft 1, which would insert language from House Bill 386, House Draft 1, with the defective effective date, the year 3000, so we can move this measure forward to address what I think is really the main issue here, which is protection of the judges and judicial staff. So that's my recommendation. Questions or concerns? First, the Judiciary and Hawaiian Affairs members. If not, I want to ask CPC.
Members of Consumer Protection and Commerce, any questions? Representative Pierce?
Legislators would not be included in this. This would only focus on judges and judicial staff whose duties put them at risk for acts of violence or threats. Any other questions? If not, let's move forward to a vote. So the recommendation is to pass HB 1916 with amendments. Representative Miyake.
Voting on House Bill 1916 with amendments, Chair votes aye, Vice Chair Takayama is excused. Representative Evslin.
Aye.
Representative Ganadin.
Aye.
Representative Holt.
Aye.
Representative Ichiyama. Aye. Representative Iligan.
Aye.
Representative Kong. I vote aye. Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you very much.
Members of Consumer Protection and Commerce, same recommendation.
Okay, voting. Go ahead.
Yeah, go ahead.
Voting on HB.
Chair?
Yes.
Comment?
Comments?
Yeah. You know, given the testimony from OIP and the state archives, I appreciate you narrowing the group of people, but I don't know how that changed their issues. You know, I mean, if you're talking about just current, you know, judicial staff and judges, that may be even narrower than all retired judicial staff and judges. But I don't see how it helps state archives with their issues on you trying on this bill, requiring them to be able to redact stuff, knowing who it should apply to. Similarly with OIP and their issues with the open records laws. So with that, at this point, I still have reservations on this bill, and we'll be voting no. Thank you.
If it's okay, Chair Nakashima, I could briefly respond. My only observation is that we did not receive any of these concerns and testimony on the previous bill. OIP and archives did not testify. Now, that doesn't mean that they don't have concerns, but that's all I know. And I think moving forward, I would seek their testimonies so that we can find out if they still have remaining concerns. So this would just be an opportunity to do that.
And I appreciate that.
So
And-
I appreciate that you
but,
going yes
you know,
with reservations. Good observation.
Based on their
Appreciate that.
testimony today,
Appreciate that.
you know, they didn't say, well, we don't have concerns with judges or judicial
Yep.
staff. So
Thank you.
Okay. Vote.
Okay, voting on HB 1916, Chair's recommendation is to pass with amendments. Chair, Vice Chair vote aye. Representative Model. Aye. Representative Bellotti.
Aye.
Representative Hashem. Representative Hussey Burdick. Excused. Representative Gates. Aye. Representative Lowen. Representative Onishi with reservations. Okay. Representative Tam.
Aye.
And Representative Pierre. Thank you, Chair. Your recommendation is adopted.
Thank you.
Next, House Bill 2524, cognizant of the opposition from the Real Estate Commission and the concerns from the Ombudsman. I would like to move this forward as a vehicle for continued discussion about this important matter. I'd like to move it forward with amendments to defect the effective date to the year 3000 and make some technical amendments. I'm going to leave blank the part of Section 1 that says how long before the Ombudsman has to report. And it would, if this does get taken up in the Senate, then perhaps at that time you could make your suggestion as to how long it might take. But I recognize that we've got House Bill 1814 and the LRB study to move on as well. So this is merely a vehicle to continue forward with this discussion. So my recommendation is move out HB 2524 with amendments. Questions or concerns, members? From the Judiciary and Hawaiian Affairs first. If not, I'd be happy to take questions from CPC.
Okay. HB 2524 as with amendments, members of Consumer Protection, any questions or comments? Representative Perrick. Okay, thank you very much.
Let's go ahead with the Judiciary and Hawaiian Affairs vote first. So recommendation pass out HB 2524 with amendments. Representative Miyake, please take a vote.
Voting on House Bill 2524 with amendments, noting the excused absence of Vice Chair Takayama. Are there any reservations or noes? Seeing none, Chair, your recommendation is adopted.
Thank you very much.
Vice Chair.
Voting on HB 2524, Chair's recommendation is to pass with amendments, knowing the excused absences of Representatives Hussey Burdick. Any members voting with reservations? Any members voting no? Rep. Perrick voting no. Okay. Thank you, Chair. Your recommendation is adopted.
Okay, thank you.
So we're going to recess to allow the CPC members to leave, and then we'll reconvene to continue the rest of the JHA agenda. Recess. We are reconvening the committee hearing of the Committee on Judiciary and Hawaiian Affairs. This agenda, the 2:02 p.m. agenda, was a joint committee hearing with the Committee on Consumer Protection and Commerce, 2:02 p.m. Thursday, February 15th, 2024, here in Conference Room 325. We have already had a hearing on the first two measures, and we have had decision-making on those two first measures. Now we're moving on to the third measure on this agenda. House Bill 2426 HD1 relating to relative resource caregivers. This clarifies when a relative seeking to be a resource caregiver for a child is entitled to an administrative appeal for denial of a foster home license. First up, we have testimony from Lynn Yeomans, Deputy Attorney General.
Good afternoon, Chair. Thank you for the opportunity to testify in support of this bill. As the Deputy Attorney General, who often has to file the motion to dismiss an administrative proceeding when a relative is filed in the wrong place, I appreciate the opportunity to give clarity to folks so they know which forum that they need to make their complaint to. Thank you.
So you support this bill?
Yes, strong support.
Strong support. Oh, that's great to hear. Thank you very much. Next, we have testimony from Kathy Betts, Director of Department of Human Services.
Good afternoon, Chair and members of the committee. I'm not Director Betts. I'm
Or her
Daisy
representative.
Hartsfield, Social Services Division Administrator. This is a administrative measure. The department did submit written testimony in support. We agree with the testimony submitted by the Attorney General's office, and we do believe that if passed, this bill will decrease the amount of frustration that relatives feel when they go through the incorrect process in trying to challenge the decision regarding placement of relative children. And I'm also available for questions.
Thank you very much. Appreciate that. That's all the testimony we have received on HB 2426 HD1. Is there anyone else here wishing to testify on this measure? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Move on to House Bill 2428 HD1 relating to the Child Protective Act. This adds a definition for exigent circumstances and amends the definitions of harm and imminent harm, clarifies when the police may take protective custody of a child, and when the department may assume temporary foster custody of a child when exigent circumstances are present, and creates a judicial process for filing a petition for an order for protective custody, including the circumstances where such an order may be issued without notice and without a hearing. On this measure, first up, we have testimony from Lynn Humans, Deputy Attorney General.
Good afternoon, Chair and members of the committee. I testify again in support of this administration measure. As you can see from our testimony, and I will stand on the written testimony, that we asked for some amendments to the House Draft 1 for clarity and to add some additional procedure to make sure that the administration measure is as clear as possible.
Thank you. Next, we have testimony from Judge Viola. We're so lucky that you get to be here.
I am, thank you.
We are lucky.
Oh, I am lucky.
Please proceed.
Good afternoon, Chair, committee members. As we said in our written, Matt Vile, I'm sorry, Senior Family Court Judge of the First Circuit, our written testimony said we were grateful to the Committee on Human Services for the amendments that they put in this bill. In its current form, we think it's a good bill. We support it. We don't think any further amendments are necessary. My written testimony, if I may, my written testimony didn't include any comments on the, I think some of the proposed amendments of the Department of the Attorney General, the Department of Human Services. We have been in discussions, but we just kind of ran out of time to come to some common understanding. With respect to the proposed amendment to amend Section 587A-9, I believe, with regard to the type of information that would accompany an ex parte motion for an order for protective custody, if that amendment is adopted, we'll continue to work with the departments to try to come to some common understanding.
Okay.
Thank you. I'll be available for any questions.
Thanks, Judge Viola. Appreciate it. Next, we have testimony from the Department of Human Services.
Good afternoon again, Chair, members of the committee. Daisy Hartsfield on behalf of the Department of Human Services. The department did submit written testimony. This is an administrative measure. The testimony offers comments as well as defers to the Department of Attorney General's suggested technical amendments and proposed amendments to Section 587A-11, subsection 9 of the revised statutes. I just wanted to add to the testimony that the bill was submitted in an attempt to address concerns that have been expressed over a number of years in regards to removal of children from their family home. The department believes that the bill addresses that concerns, and if there are any further questions, then I'm available for any questions. Mahalo.
Thank you very much. Next, we have testimony from the Hawaii Coalition for Child Protective Reform. Marilyn Yamamoto, please proceed. You want to unmute yourself and proceed?
Okay, can you hear me now?
Yes.
Okay, thank you, Chair and Committee. I'm here to stand on the coalition's testimony, written testimony. I hope you read it carefully because I'm here to answer questions, but mostly to recommend respectfully that this committee defer the bill for the reason that our coalition has not been able to have a meaningful discussion with either DHS or the AG on the issues of imminent harm, namely that Ninth Circuit rulings are not being considered here in this bill. And it's extremely important to differentiate when a court order is needed and when a child can be removed without a court order. Thank you.
Thank you very much. Next, we have testimony from Nonohe Botello. Please proceed.
Aloha, Chair and Committee. I concur with Marilyn Yamamoto on her testimony, and I stand on my written testimony. Did you get my written testimony? Because I was told that you may not have.
We did receive your testimony. Thank you.
Thank you. Okay, and I stand on my written testimony, and I just wanted to add a couple things in addition to. Right now, 2428 does not have any remedies for parents who are falsely accused and with evidence that they can obtain through their cases. And it has no mechanisms for complaints or false allegations, conflicts of interest, or fraud. Fraud does occur, and this is a very sensitive topic. We do support Gianna and Ariel cases. I'm involved with that. And we wholly support having investigations for those cases and those types of cases for children to be removed. However, when there is not evidence and no complete investigations on fraudulent reports, we have dozens of those. Out of the 20 cases that we vetted in the last year, 15 of those cases were full of fraud. And we are concerned for parents who have children who are illegally removed and also falsely accused. And this bill does not have any accountability or enforcement attached to it. And we want to know what the accountability is to the department and to all those who are involved. And I just want to say that I want this bill to be deferred for further discussion. But at the end of the day, I want to say this. I have had a bill in session for 12 years about putting children under first-degree murder. And I want to say that the single most important thing that the legislatures can do now is to put children under the first-degree murder law to protect our children so that their alleged murderers can get the full extent of the law applied to them.
Thank you very much.
Like any other criminal case. Mahalo.
Thank you very much. Appreciate your testimony. And next we have testimony from Derek Carlin in opposition. Is there anyone else wishing to testify on HB 2428 HD1? If not, questions, members? Representative Ganadin, please proceed.
Department of Human Services. Good afternoon.
Good afternoon, Representative.
I'm looking at page 5 of the bill. Wait till you get there with me.
Okay, you can go ahead.
Paragraph 3, it discusses the terms upon which this might be enacted, basically upon which you can take a child from somebody's house. Of course, 1 is with the consent of the child's family, 2 is on order of the court, or there's 3, which is the new one, right? And I see police officer here. What kind of training does the Department of Human Services engage in or is planning to engage in with training officers to determine reasonableness here? So for what's reasonable for one culture might not be reasonable for another culture. What's reasonable for one officer might not be reasonable for another officer. Usually, this is why we have hearings. This is why we bring people before the court and we have evidence. I want to support this bill. I'm nervous about police officers making this call right away without training.
Yeah, currently police officers do make that call. The training varies depending on the police department because we have different police departments in the different counties. I can only speak for the Honolulu Police Department because that's the only one I have personal knowledge with. In the past, we did provide training when they had their new recruits, but with the new leadership, we have not had the opportunity to have discussions on providing those types of trainings to current recruits. So to date, there has been no trainings that the department has provided our officers from the Honolulu Police Department, but we do work with their officers in regards to these types of cases.
Is there a training protocol in place, you just haven't been able to implement it?
I would have to speak with the current leadership. There was one in the past, but I have not had an opportunity to discuss whether or not that's something that they want to continue how they had done in the past.
Does this bill allow for the Department of Human Services to expand upon that conversation between the county police officers?
We can have that conversation even without this bill.
Thank you.
Thank you. Other questions?
Representative, I can answer that question.
You want to ask the question of the police officer?
Redirect the same question to the gentleman representing the Honolulu Police Department.
Yeah, so sorry, Chair, Vice Chair, committee members. I had a technical issue and I wasn't able to give my testimony. But we do support this bill with the recommendations from the Department of Human Services and the Attorney General's office. As far as training, Representative, like you were asking for earlier, there is training internally. It's not directly through the Department of Human Services, but we do give recruits an annual recall training to our officers on a yearly basis. We do have to admit that we have to update our training here and there, but I believe that we have enough training to recognize issues at the scene, whether it be visible injuries or just the the child or the parent or the family is not working together. So we believe that our sufficient right now is our training is sufficient enough, but we always could use improvement, and we may have to work with the Department of Human Services and the other domestic violence coalitions in getting that training. And in actuality, we are in discussion right now.
Okay. Thank you. Thank you very much. If you have any written testimony, officer, please send it in. I don't see it on our list. So maybe you could just email it in to my office. That'd be great.
Okay. Yeah. I apologize, Chair. We thought that it would have meant been in. But for us, as far as exigent circumstances, we do like that language because it gives a broad range of circumstances that the officer would be able to evaluate at the scene. But I'll make sure that you get the testimony, Chair.
Thank you. I appreciate it very much. Thanks very much. Any other, anyone else wishing to testify in this measure or other questions? If not, thank you very much to all the testifiers. Let's move on to the next measure. House Bill 2555 HD1 relating to the Child Protective Act. This amends the definition of harm under the Child Protective Act, requires a service plan to include an evaluation or assessment of family members in the family home who are perpetrators or alleged perpetrators of domestic violence by a service provider trained in domestic violence. First up, we have testimony from Kathy Betts, Department of Human Services, or her representative.
Good afternoon again, Chair and representatives, all committee members. I'm Daisy Hartsfield, Social Services Division Administrator. The department did submit written testimony. It appreciates the intent of this bill and offers comments and concerns. The primary concerns has to do with consistency of the definitions in sections 350-1 of the Hawaii Revised Statutes, as well as section 587-4. The other concern has to do with duplication of services in regards to providing a service plan. The department currently works with each parent, regardless if they are the identified aggressor, and works with each parent to do a service plan. So there is some concern that there might be a duplication of service the way the current bill is presented. And if there are any questions, I'm available for questions.
Thank you very much. We have testimony and support from Marilyn Yamamoto. Testimony with comments from the Hawaii Coalition for Child Protective Reform, Ms. Botello.
Aloha, thank you. Only adding comments to this bill again. You know, we're trying to redefine the word imminent harm, extension, and I'm getting confused because you have two bills that are trying to do the same thing, the same side of the coin. And I would like to defer this bill for further comments on, and discussion on this bill. And again, we oppose because there's too many definitions and too many duplicate bills. I mean, what is it? You know, that's my biggest question is what is we going to end up with here? We need to have further discussions. And I want to say again, one more time, so it's clear and on the record, the single most important thing that we can do for kids like Chiana and Ariel is to put them under the first degree, children under first degree murder in this state, because children are not included under our first degree murder. Mahalo.
Thank you very much. Next, we have testimony from Peggy Hong. Welcome, please proceed.
Good afternoon, Chair. If the committee would allow my husband to stand with me.
Of course, of course.
Thank you.
I commend you and your family for your strength in such tragic and traumatic circumstances.
Yes, we're
So
testifying
please.
as grandparents. Our daughter passed away and took her own life April 29, 2021 because of extensive domestic abuse. She was destroyed emotionally, psychologically, physically. She left behind her twin children, a boy and a girl, who were 11 years old at the time. They lived with the father, and by August of 2021, they both showed suicidal ideations. One actually attempted. Child welfare was called. They took them into custody and confirmed the suicidal ideations. And at that time, family and friends had meetings with child welfare about the domestic violence they had personally witnessed. We had a copy of our daughter's journal that we found after she passed, where she explained what her partner had done by dragging her down the stairs by her hair, dropping tables on her legs, punching holes in the walls, threatening to kill her if she left, and more. We made copies of those pages and gave it to child welfare, and that was not enough information for them to determine domestic violence and danger to the children. By October 2021, Oahu Child Welfare returned the children to their father. He sold the home, he moved off Oahu, we did not know where they were. For 2 years, we did not know where they were until February 2nd, 2023, we found out they were in Kapa'a, Kauai. And the reason we found out was the father, 6'2", over 200 pounds, two-fisted, punched our grandson in the chest. He fell backwards, almost hitting his head. He tried to call for help, 911. The father took the phone and destroyed it. He talked to his twin sister and decided that that was enough. They ran out in the dark of night. They ended up at the Lihue police station, and on February 6, 2023, they had their forensic interview. They described their life of abuse. They described the 2 years when Oahu Child Welfare returned them to the father, where he pulled their hair out by the roots, hit them, slapped them, kicked them, threatened to kill them, and more. They suffered like this because child welfare could not assess the domestic violence component and returned them to their father. We were absolutely horrified and felt terrible, as you can imagine. If you look in your folder, Andrea Grable submitted her testimony, and in that she clearly delineates the information she gave to child welfare about the domestic violence she had personally witnessed, and nothing was done. What we'd like to say is what our granddaughter wrote. I'm scared, even terrified, that if we go back with him, he will kill us, or he will abuse us so we will be like our mother. I'm afraid that after I write this, he will want to hurt me seriously. Please do not send me back. I fear for my life and my well-being. This is the man that Child Welfare said was fine and did not find domestic violence issues. Now, DHS has written in their testimony that they do assessments. What I'd like to say is we are the classic example of why you need a specialist in domestic violence. Whoever evaluated the father and said he was a competent parent absolutely, completely, monumentally failed. Our grandchildren, the forensic interview, and the therapist can certify to that. You need an assessment made by someone who is specialized in domestic violence and not just any old so-called evaluator. They also talk about needing more resources and time. Our comment is, when you're saving the lives of vulnerable children, fight for the resources, find the time, ask for more staffing, and save the lives of these children. Do not let resources and time be an excuse for not saving children. Thank you for your time. We really appreciate your attention, and we hope that HB 2555 House Draft 1 can be supported, because we do need to recognize domestic violence, because child welfare is unable to make those assessments. Thank you.
Thank you. Thank you very much. And I really appreciate you coming to share with us your perspective and take a tragic situation and try to do something positive with it so that others don't have to go through that. And my heart goes out to you with the loss of your daughter, Paula. And to your grandchildren, please pass on the appreciation of this committee. Next, we have written testimony from Jackie Hong, Andrea Grabo, and Lori Tochiki. Please proceed, ma'am.
Thank you, Chair, Co-Chair, and members. My name is Jackie Hong, and I want to introduce my nephew that I love so much and so proud of, Kaya Grabo. He's so strong to stand here to help me today. I am in the same family as Peggy and Chris Hong, and these are our children. Thank you, baby. They've been through so much. I'm a retired social worker of over 4 decades. I've worked with multiple hundreds of child welfare cases. But until my family personally experienced this tragic situation, you'll never know till it's personal how really horrible it is. I read the newspapers about our little baby Gianna, our baby Ariella. And I cannot understand, as a professional social worker, how we continue this over and over again. I have many friends retired, currently working with child welfare. There's no one person to blame. I think it's a system that we need to look at very carefully, though, and reorganize. We need new laws, policies, and procedures, because what we have is not working. And I will tell any administrator there, look at the newspaper, it's not working. I look at my own family, of my niece and nephew, and the loss of my beloved niece. It's not working. I don't have all the answers, even though I've dedicated my life to social work. I don't have all the answers, but I know what we're doing is not working. I'm sitting on a committee now that a bill passed and the governor appointed some DHS people, some of our community people, and I'm not happy where the group is going. We can sit and talk about culture and kumbaya each other, but we've got to get down to some brass tacks. I want all these cases, like my niece and nephews, a deep forensic audit to identify what didn't work in Gianna's case, Baby Ariella's case, Peter Boy Kema's case. What didn't work? I don't care if people's names are named, but we cannot Our state cannot continue this. This department cannot continue. Okay? I know it's difficult. Tons of my friends are retired from there, and they're so traumatized they can't even speak up anymore in their retirement years. But I have to, because it affected my family. So I support this bill. It may need some amendments, but I support it because I believe domestic violence is growing and growing. I know licensed psychologists, licensed social workers who work with domestic violence, but you need specialized people to identify and listen to families. My family, like Peg said, we called, we disclosed the violence, everything. And nobody listened and returned these two babies to their father, who beat them up again for 2 years. And we couldn't find them because he crashed their phones. Finally, we got them. Early in the morning, they took off on their own down a black highway, a dark highway. Well, he was looking for them with this truck. And they had to get a friend to help them go to the police. And finally, they were removed and now with the grandparents. And we're scared that they're going to put them back with this man who's now homeless in Kauai, has no jobs. And is he going to beat my nephew up again? My nephew could have died. He punched him in his chest. He could have died his heart. So please, do what you can do on this bill and other bills, the No-He's bill, because I cannot read any more papers and listen to news about this. We cannot protect ourselves. I'm a member of NASW, National Association of Social Workers. I tried when baby Ariella died to get them to stand up. Nobody did. I'm disappointed in them as a professional social worker. I went to Liliuokalani Trust. What was I told? Oh, we don't get involved with politics. I said, well, is the death of a child politics? No, it's not. It should affect everybody here. Please help these children.
Thank you. Thank you very much, Ms. Hong. Appreciate your testimony. Is there anyone else wishing to testify on this measure, HB 2555 HD1? If not, questions, members. Representative Ganadin.
To the Department of Human Services. Firstly, our gratitude to those that testified today, and we just heard some of the most compelling testimony I think that probably ever heard before this committee. This is the last committee that's going to be hearing this before it goes to the floor and maybe crosses over to the Senate. There's not a FIN designation. However, we just heard that through your testimony and through written testimony that there might be an additional assessment required here. Does the department have the resources to do this additional assessment where we would pass this bill?
Is it in our budget? The answer is no. Do we have resources available? The answer is yes. The Domestic Violence Action Committee had partnered with the department to provide the expertise to our staff in making assessments that may involve domestic violence issues. So that is something that is available. There is training that they provide to our staff. We have funding for those types of training, so that is available. I have to agree with you that the testimony is compelling, and I have had constructive, tough discussions with Mrs. Hong, with Nohe Botello, with Marilyn Yamamoto, and they all have a point to make that it's not one individual. This really is a system, and there's no easy solutions to it. And I believe that discussions and having bills like this is a way that we can better serve the children of our Aina. And so can we make changes? Yes. Do we want to make improvements? Absolutely. We'll do what is needed. Do we have limitations, however? Unfortunately, the answer is yes. There are issues with trying to get things done quickly, especially if it involves procurement, so that causes delays as well. But I believe that we have the right people in the right places. I believe that we have partnerships that we're making ourselves available to listen to the concerns and try to address it. So I am hopeful that we'll be able to make some progress, or at least better progress this session than sessions that I have heard where they did not, well, advocates did not feel as supported. So I just wanted to add that.
Is it possible to work with the director and potentially amend your budget for the next biennium, considering that we might pass this bill, and require the department to work with appropriate providers to do these new assessments?
Well, on behalf of the division, I can ask for that in our budget request. I'm not sure what would happen once it leaves the department, because it's part of the executive budget. The governor's office is involved with that as well. But
I think when the previous testifier discussed brass tacks, I think that's what we're talking about, like how much is this going to cost, and how capable is your division in effectuating this proposal. So, yeah. Thank you so much.
Thank you. Thank you very much.
Thank you.
Any other questions, members? Any other questions, members? You really want to say something? Briefly, why don't you come on up? And I don't know what you, is there a question I can ask you to allow you to say what you want to say?
May I make a comment very quickly? I'm a retired human resources director from the University of Hawaii. The employees who work in that department are civil service employees, and what we found is great resistance in terms of actually administering properly supervision, direction, incompetence versus discipline. From my perspective, the department needs better leadership, stronger leadership to take appropriate action. I've worked with HGE. I know Randy Pereira. I mean, blah, blah, blah. Things can happen and things can move. At the university, we fired tenured professor for less. We need to take action, as my sister-in-law says. And what has to happen is strong leadership willing to do what needs to be done. And actually, when Daisy and I met, I told her, I can tell you how to do a pilot program to begin new ways and systems to operate in child welfare. I never got called back. Thank you.
Thank you. Thank you. Any other questions, members? If not, let's move on. Thank you very much. Again, thank you very much to the testifiers and to your family. Next, we have House Bill 1922, HD1, relating to wildlife. Expands the Department of Land and Natural Resources rulemaking authority to include any rule deemed necessary to protect certain wildlife. On this measure, we have testimony from the Department of Land and Natural Resources. Thank you for your patience.
Aloha, Chair, Vice Chair, and members of the committee. We stand by.
And you are?
I'm sorry. I'm Jason Omick with the Division of Forestry and wildlife biologist with them, and I'm here to say that we support this bill.
Okay. Thank you very much. Next, we have testimony support from Lois Crozier. Is there anyone else wishing to testify on HB 1922 HD1? If not, questions, members? Yes, Representative Souza. Mr. Omick.
Thank you for being here. I basically just wanted to know, I noticed there's been kind of an influx of bills where DLNR is getting involved in rulemaking or providing permits, et cetera, that perhaps would just be best left to be dealt with at the federal level, like it currently is. Environmental law and policy is very complex and complicated. And so what exactly are you guys trying to do with this specific measure, and how would that interfere or compound what is currently going on with federal wildlife laws?
Well, I can't speak upon all federal wildlife laws, but we've had a bill a few years ago for adaptive management, where basically when we do rule changes, we go through the Chapter 91 process, and with that is public comment and public hearings and whatnot. And so this is, the previous adaptive management bill allows the department to go through a rule change process with a 30-day notice for people to come to a publicly heard BLNR meeting and have time to comment before that meeting, 30 days, and then we can move forward with temporary rule changes that will only last 2 years. And we've done this already. We've exercised this adaptive management twice already. We're going through another round right now for the Big Island to deal with goat problems and pig problems. So this is just expanding why we would use the Adaptive Management Authority. Right now, you know, we've listened to members of the public, hunters. They may say there's mass amount of animals in certain areas and we'd like you guys to increase the bag limits. Sometimes that could take 6 to 8 months to even go through the rule process. So this allows within a month or two, we can make those changes. We can watch those changes for 2 years, evaluate, analyze the difference of the harvest and success of hunters in those areas, and you know, decide where we want to go, if we want to keep those changes or let them revert back. And so in Puna, there was issues with pigs going into certain neighborhoods and causing problems. And so because we have an adjacent area that is a hunting unit, for us to step up and say, hey, we're going to make some changes to our hunting units to be able to take more pigs in those areas so they're not being impacted with those resources. So, and we're seeing these kind of things working. This bill here is kind of, you know, maybe bringing in information about survey data or you know, it says in light of new technology, so maybe we're able to create more censuses of animal populations and then use this type of bill to go through a temporary rule change.
Okay, thank you. My concern is that a lot of this is just duplicative with what's going on at the federal level. I see your point, but thank you for explaining.
Of course.
Thank you very much. Other questions, members? If not, let's move on. Thank you, Mr. Omick. Next, we have House Bill 1518 relating to the Hawaii Tourism Authority. On this measure, we have testimony from the Hawaii Tourism Authority. Next, we have testimony from Leimomi Khan and Luann Mahiki Lankford Favorito, all in support. Is there anyone else wishing to testify on HB 1518 HD1? If not, we'll move on since there's no one to ask questions of. To the final bill, HB 1650 HD1, relating to the Board of Education, requires the Board of Education to invite the exclusive representative for bargaining unit 5, which are teachers and other personnel of the Department of Education, to appoint a non-voting public school teacher representative to the Board of Education, and the exclusive representative for bargaining unit 6 to appoint a non-voting public school administrator representative to the board. First up, we have testimony from Wilbert Holk, Chief Negotiator, Office of Collective Bargaining. Thank you for your patience, sir. Please proceed.
Good afternoon, Chair, Vice Chair, members. Wilbert Holk, Office of Collective Bargaining. We've offered comments on this bill, and I will say this, that I think it's a good thing to have a teacher and administrator at the table in conversations around educational policy and governance that the Board of Education does. At the same time, we have to be mindful that it may create a conflict of interest also, because the Board of Education also discusses, has conversations on, and makes decisions on collective bargaining, affecting the bargaining units that those two, the teachers and the principals, may come from. So we just wanted to offer that for you, and if you have any questions, I'll be available.
Thank you very much. Next, we have testimony from Osatui, Hawaii State Teachers Association. Welcome, Mr. Tui.
Hello, Chair, members of the committee, Osatui, President of HSTA. We are in support of this. We right now have a student representative who's non-voting. We have a military representative who's non-voting. We have all these voices at the table about what happens in our schools, but we don't have one from the teachers. We don't have one from the administrators. These are the practitioners in our schools that make things happen at our schools, and they deserve a voice. With regards to talking about collective bargaining, they can recuse themselves from any discussions relating to that. That's easily done. I will say that sometimes there are board members who are spouses of teachers who have to recuse themselves from discussions related to collective bargaining. So it's not something totally impossible to be rectified. We appreciate your support on this. Thank you.
Thank you, Mr. Tui. We received written testimony in opposition from HGEA and testimony in support from the Democratic Party of Hawaii Education Caucus. Is there anyone else here wishing to testify on HB 1650 HD1? If not, questions, members? Seeing none, thank you very much to all the testifiers. Let's move on to decision making. Okay, first up, House Bill 2426. I recommend we move this out with amendments, technical amendments only. So HB 2426 HD1 with amendments. Questions or concerns, members? If not, Representative for the vote. Representative Miyake?
Voting on House Bill 2426 HD1 with amendments. Chair votes aye. Vice Chair Takayama is excused. Representative Evslin?
Aye.
Representative Ganadin?
Aye.
Representative Holt?
Aye.
Representative Ichiyama? Representative Ilagan?
Aye.
Representative Kong? I vote aye. Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you. Next measure, HB 2428 HD1. I recommend we pass this out with amendments. I'd like to adopt the Attorney General's amendments, make some technical amendments. Let me just briefly describe that we need to make some conforming amendments in different sections that define harm and define imminent harm. So it's inconsistent within the measure and in the statute, so we just need to make some conforming amendments. There's a reference in there that needs to be corrected. It should be to HRS 587A-9 parens A, and then other technical amendments. And then I'd like to include in the committee report that we recommend an effective date of July 1, 2025. But as you, the bill currently has a defective effective date, so we'll keep that in there so we can continue discussions on this. So that's it. My recommendation, pass out HB 2428 HD1 with amendments. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on House Bill 2428 HD1 with amendments, noting the excused absence of Vice Chair Takayama, are there any reservations or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Next measure, House Bill 2555 HD1. I recommend we remove this out with technical amendments. And I want to address the Department of Human Services request where they basically say, however, if the legislature's intent on the change, DHS respectfully requests that the language also be added to section 350-1 HRS where appropriate. It already has a defective effective date. Just so people know, the DHS had concerns about the difference in definition between harm and child abuse and neglect. And they're in different sections of the statute, and so we'll work to address that in our amendments. So recommendation is to pass out HB 2555 HD1 with amendments. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on House Bill 2551 HD1 with
This is 2555 HD1
correct
with amendments.
My apologies, Chair. Noting the excused absence of Vice Chair Takayama, are there any reservations or no's? Seeing none, Chair, your recommendation is adopted.
Thank you. You're doing a great job.
Thank you.
Next, House Bill 1922 HD1. I recommend we move this out with technical amendments only. Questions or concerns, members? If not, Representative Miyake. Oh, yes, please.
Oh, I'm sorry. I'm just going to vote with reservations.
Absolutely, and I appreciate your comments. Any other comments or concerns? If not, Representative Miyake for the vote.
Voting on House Bill 1922 HD1 with amendments, noting the excused absence of Vice Chair Takayama and the WR from Representative Souza. Any other reservations or no votes? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 1518 HD1. I read the testimony on this. I read the bill. The law says that anyone who is named to the Hawaii Tourism Authority as a member of the Board of Directors is subject to Senate confirmation. So this bill didn't make much sense to me. So I'm, after discussion with the tourism chair and significant reflection, I think what needs to be deferred. And if they want to come back with something a little clearer, then they can do that. But in the meantime, my recommendation is to defer HB 1518 HD1. Questions or concerns, members? Thank you. Moving on, the final bill, HB 1650 HD1. I recommend we move this out as is. It already has a defective effective date. So we'll move this on for further consideration. So HB 1650 HD1 as is. Questions or concerns, members? If not, Representative Miyake for the vote.
Voting on House Bill 1650 HD1 as is, noting the excused absence of Vice Chair Takayama, are there any reservations or no votes? Seeing none, Chair, your recommendation is adopted.
Thank you. There being no further business before this committee, we are adjourned.